Now, when they float the idea of a death tax, they're introducing it. Like,
it's coming.
Yeah, they just plant the seed, and then 2-3 years, because it's in Britton already.
We've got some fresh new young talent doing some things that I know you haven't heard before.
1, 2, 3, listen.
So Paul Snow, principal lawyer, director at HG Legal and Conveyancing. Thanks, mate. Now, it's not November yet, but we've given it a good nudge. We talked before we jumped on. What did you do this morning? You're having a swim?
Yeah, just with some Masters players. We've got a good group going. We've got about 70-odd blokes who are actively in the roster playing once a month.
Who did you play footy with? Went to full Masters?
I was a junior. Jesus Christ, I've been everywhere. I was raised in Yarraville, so okay. I played with Set in Yarraville. Then I moved back to, Mum remarried, went to Bundoora, played a bit out there. But when I came back, I played for Spotty for a couple of years, did a medial while my wife was pregnant. So I'm like, I can't play footy. Went into professional boxing.
Yep.
Did a few fights. Still got the boxing gym in my garage. So I still take classes on Sundays, just open sessions for the boys to come, whoever's recovering from an injury and wants to keep their fitness levels up. But with the Masters crew, we've created a really good culture. We're all a bunch of larrikins. There's about 14 of us at the Legends game at Marvel last night. And then there's maybe 4 or 5 of us that will go for a dip in the morning. So it's really it's focusing more on, that camaraderie, having your tribe, men's mental health, and really your brothers having your back, and I found last year was the first year of the club, and I didn't realise what I was missing. I thought I was very much a lone wolf. I train by myself. I've got my own programs. I'm fine. But then once you have that band of brothers where you're like, well, I know I can go to my mates in times of need. And even they've seen me in down moments, and they'll know. They'll Snowy, what's going on? Come back to the club or come for training. And it's just that support network that you need, I think. And we're starting to now branch out into other things, we'll do a silly Sunday as our Mad Monday type thing. A couple of blokes are going to Darwin for the National Carnival, and this weekend we're actually going to Shepparton for just a local country carnival, which is like a round robin thing, but there's 6 of us staying in an Airbnb. So it's good fun because there's no real morons or no one trying to, take someone's heads off. It's just social footy. And normally the opposition's like that as well. So you have good banter on the field. It's not like that white line fever, which I had to remind myself because, last year I took it a bit seriously. But no, it's good fun hopping in the beach and I think with what we do in our profession and the stresses and some of the anxieties we experience from our clients, because there's a lot of vicarious trauma coming from clients when they're going through tough and difficult situations. It's just good to keep a level head and just sets me up for the day to know that nothing's really going to sway me from performing. And then even sometimes if I have a tough day, I'll just go for a dip on the way home. And that's why, when you live in Torquay or you live down in the Ballerine area, you think you got to appreciate where you live. We live in one of the best parts of the world.
It's a pretty amazing place.
And I think if you express that gratitude naturally, then positive things come from that. And you just look at the world differently. You just have this different perspective of being grateful for the life that we get to experience. Especially, and, when I was studying law, I majored in politics and did a bit of international relations. And you get to learn that when you live in a capitalist society, there has to be suffrage for people to enjoy the benefits. So there's a direct link, whether it's through whatever we consume on a daily basis, because societies are very materialistic, as we discussed, everyone's consuming. There has to be someone suffering in the world in order to have that imbalance. And unfortunately, we can't have a utopia where everyone's equal.
They've tried that, didn't work.
And there's different types of societies in terms of capitalist, liberal capitalists and Marxist socialists. They still exist, and we're still trying to work it out because the GFC and COVID proved that, liberal economies aren't exactly the answer. But then you look at the tax system and you're like, well, why are we living in Victoria?
Yeah.
The amount of taxes that are coming out in this state.
I think you said it because it's beautiful.
Well, we live out here because we're here, but the amount of, as a business owner too, small business makes up 70-80% of the economy, and they're taxed higher than anyone else, really. And we pay taxes on taxes. You're paying your PAYG tax, and then you pay tax on the wage that you get paid. It's just ridiculous. But
A little bit of land tax, a little bit of windfall gains tax.
mate,
it adds up.
They've worked out how to tax the SMSFs and the corporate trustees, but they're always coming after that. And now when they float the idea of a death tax, they're introducing it.
It's coming.
Yeah, they just plant the seed, and then 2-3 years, because it's in Britain already.
Yeah,
it feels like it's a bit of a social experiment. Like, we'll see if we can tax the unrealised gains for SMS over 3 mil. Then once it works, they'll lower the threshold to $1 mil. Because they need to find money. They don't have any.
Yeah.
So I just think our government's been a bit irresponsible with the budget, and Victoria's got
just a
the
little
highest debt in the whole country at the moment. And so
what is it? It's New South Wales,
Queensland
combined.
Yeah. It's like we pay $23 million in interest a day. Why? And that's coming out of the public purse. Like, it's coming. We're paying that. The MPs aren't paying that, and they're making the decisions.
Yeah.
So, but we could go on for that.
Well, it's important because it speaks to a few things. Like, it speaks to a few things in our worlds. How people, as business owners and as families, make do and may have to make particularly good use and good decisions with the income and the assets they have. But also, I don't know, maybe it was off air before we started, but just talking about how you actually make sure that you protect what you've got. And if you're buying assets, you're buying properties, or if you if you're leaving it to chance that your assets are going to go to the right people at the right time, don't.
I was talking about this earlier, where I'm starting to have serious conversations with people about getting their wills in order. And just retirement planning isn't for retirees. Succession planning isn't for people going into their 60s. If you're a young professional, even if you're an influencer, what are you going to do with that channel? We've got all these we're in a digital asset economy now with cryptocurrency, where your Facebook pages and your digital currency is worth something now. And if you're, like you said, if you leave it to chance, you're literally playing Russian roulette. You're basically gambling it away. The sad fact is, because of the way our death taxes work now, because it's essentially paid on the binding death benefit payment after you die. If that doesn't go to a financial dependent or your spouse, and it goes to an adult child, you're paying the death tax there. It's just no one calls it what it is.
So maybe let's talk about this. We'll get. I've talked about this on the podcast before, but it's definitely worth repeating. Let's talk a little bit about, like, people have this perception that that everything will just go to the right people at the right time. Right? If I die, I'm good. That's my super is going to go to my spouse or my kids or whoever it might be. But maybe just expand on what you said there in terms of the reality of what happens if a death benefit from super, from a taxable component of super, goes to a non-dependent beneficiary, like an adult child.
It's scary because people are actually now filling out their death benefit payments on their deathbed and claiming it there and there if they're terminally ill, because they don't want it to go elsewhere. And people don't realise, maybe they do, maybe they don't. But, when we're advising clients, we're going through the whole gambit of their assets and liabilities, and we go, all right, which industry funds are you with? Do you have an SMSF, which is a self-managed super fund that you control yourself? And people think that their super's theirs. You're a mere beneficiary under your trustee, which means you don't have an absolute legal entitlement to your super. That's why this is how the government set it up, so super companies can play with your money on the stock market exchange. Like, you can choose your investment strategies with an industry super fund, or you can take control of it yourself under an SMSF. Now, people will think, okay, everything will take care of itself. If I die, I've nominated my wife. But under superannuation rules, it's very lax in rules of evidence and procedure. Like, people outside the gambit of your family will make claims on your estate, and they won't do it through the court system because it's too expensive. They'll do it through the superannuation tribunal by telling the trustee, hey, I believe I'm entitled as a beneficiary under this estate, so I want a piece of that pie.
I think when you tell clients that the discretion about where your super fund goes is not, if you have a non-binding nomination or if you have an invalid nomination, is at the discretion of that super fund, that industry fund, that retail fund. It's shocking for most people.
Oh, they don't. No, majority, 80 to 90% of clients I talk to don't realise that their super is not theirs, and it's not dealt with as part of their estate unless you craft your will specifically to say, I want my super paid into my estate, or you create a superannuation proceeds trust, which is a form of testamentary trust that can give you the tax minimisation and tax advantage strategies. I mean, the tax office will still try and trace those payments to see where they go because they're in the interest of collecting tax. But yeah, 89% of clients just have no idea. And if we don't advise our clients of that, we're negligent because we know this information. We talk to financial planners all the time, and we're giving clients proactive advice is, if you don't know what this is, go talk to your financial planner, and then we can assist you in completing the will because binding nomination needs 2 independent witnesses. When we're signing the will, we have 2 independent witnesses. It's a perfect opportunity to do it right there and then. And then if someone has an SMSF, we have to go and create a bespoke binding nomination. So under your trust deed, it'll allow you to do a binding nomination, but unless it's bespoke to the particular SMSF trust deed, then it could go anywhere. And the amount of blended families we have, I was raised in a modern family. I was raised in 2 divorces. I've experienced the step siblings, the half siblings. I've seen it go wrong in so many occasions. And, you know, we've got clients where their only will is with the ex-wife. They get a divorce, and all of a sudden that divorce order means your will's invalid. So everything's up for grabs. And everyone, you know, you'll hear the comment, I even heard this morning, the comment saying, oh, my money will go to the government. It's like, well, it's not entirely accurate. Your money in your estate was dictated by legislation, but it's up to a next of kin to go and get that. Your super is really up for grabs, and that's what people see. No one's got money to go spend 10, 20, 30 grand in fighting litigation for the next 2 to 3 years, even longer. What they want to know is, when can I get super? I've got clients, they come in before the funeral saying, oh, not even a death certificate, and they're asking about superannuation. And I'm like, okay, red flags. You can sort of, when you've been in this industry as long as I have, I trained in family law for 10 years while I was studying, thinking I'm going to be a family lawyer. Then I had kids. So I diverted. But when you've been in this industry so long, you see the war stories and you experience it, and you're like, okay, well, we can give that proactive advice to clients. And I feel like clients need to take more ownership and responsibility over their own lives, because they'll come in. The worst case scenario is that I've had draft wills done. We get draft wills done pretty quickly, and we have reminders so that.
Sign your will.
Yeah. Come in. Listen, if you can't come in and you're traveling, do it as an informal will. You can still get around the execution requirements and submit an informal will to court. If you can't come into the office, that's fine. Just sign it before 2 independent lay witnesses. And we're giving that proactive advice to say, hey, all right, we understand life's hard. You might not be able to come in and get it done, but just get something signed. I had one will recently where the client's literally signed it on his deathbed with no witnesses, and it has a draft watermark. Now, in case lawyers will know, draft watermarks will invalidate a will. And his only original will appoints a family member who he had litigation against. Yeah. So he doesn't want her to be executor. And so, unfortunately he couldn't come in because he was terminally ill. So we're going to try and get evidence and an affidavit from the doctor and the treating physician to try and get that draft will up. It's not good chances, but we'll do our best to get the result for the client within the parameters of the law, of course. But going back to the superannuation tribunal, there's no rules of evidence and procedure. It's at the discretion of the trustee, and the trustee's only worried about getting sued. So they may make a decision in your client's favour, but then there's further submissions made from an ex-wife or a de facto that has children who may have autism and have further needs, and then all of a sudden the decision gets changed, and then there's money dispersed elsewhere. Now, when you think about testamentary wishes, in the eyes of the law, they're extremely important, and when they're crystallised in a will, they're binding. Testamentary wishes don't really exist in the superannuation space, but if you think about when someone says, oh, he would not have wanted this or she would not have wanted this, mate, you think about where the super payments are going. It should really only either go to the spouse or the kids.
Yeah.
And there's just a whole bunch of I heard this morning, there's an ABC article where a 68-year-old uncle's made a claim on a death benefit payment, and that's currently being considered. And the more noise about it, the more I appreciate that, because I'm like, people need to know they need to get their lives in order. And it's not just, like I said, at that retirement age, because anything could happen. You could die crossing the street. You hear of people who are fit, and we try and stay fit for our kids and lead by example, but we could die of an aneurysm at 41, 42.
Yeah.
Who knows? And it's scary to think that, but people just need to take responsibility. And if you got kids, I mean, you're an adult, right? Get it sorted. Like even me, I'm looking into my super and how I can maximize my assets. I've got 3 kids. I don't know how they're going to afford a house in this economy. Ultimately, our generations were raised with owning a home, having a family. I don't think this next generation will be raised with those goals in mind, but they need to be financially well off to be able to do whatever they want to do, and they buy a car, put a deposit on a house, whatever. You know, you just want to make sure that your financial legacy is secured for your kids moving forward. And that's our primary goal as parents, I think.
Yeah, I think we spend, as financial advisors, we spend an enormous amount of time growing people's wealth. It kills me to think that we don't actually protect it on the tail end. But all of that preparation, it doesn't, like you said, it doesn't happen. You can try unsuccessfully in many instances to try and rectify things at the very end. We need to be preemptive early on. And to the question of what are we going to do about our kids? I've got 5 kids and I think about it a lot.
Wow.
And I mean, the best thing my old man did for me was have me investing small amounts incrementally from an early age, and with a bit of discipline, with a bit of enforced discipline, followed by some self-discipline to say, hey, if you put X amount into an investment, I'll match it. And once you got into the habit of doing that, we let the magic of compounding carry on. I think people should be thinking very, very early on. A lot of our clients now, even when they're contemplating families, we're thinking about having money held in trust for their kids, small amounts regularly over a long period of time, because they're going to need it.
Yeah.
They're going to need a leg up for education. They're going to need a leg up for property, starting a small business, travel, whatever it might be.
Hex debts. So I wholeheartedly agree. And I missed the boat on contributing into my super as young as 20, 30. Because I spoke to an accountant during COVID about taking out that 10 grand cash payment.
Oh, yeah.
And he told me, he said, compounding interest, in the end, when you're 65, you're losing about 170K. And I was like, and people, like the layperson who's not au fait with superannuation and compounding interest, they're not going to ask those sort of questions. They're just going to take the king.
And mate, they were dishing it out to anyone. You didn't have to. You didn't have to try hard to get that money out.
And I know heaps of people that took the payment, and I considered it until I asked the right questions, and I'm like, I'm not sacrificing 170K at retirement. I mean, I don't believe there'll be any real form of retirement in the digital economy. I think work just changes. And, you know, if you think about when the retirement age was actually invented, the average living age wasn't even to 65.
Yeah.
So the guy who invented the retirement age basically said you've got to work until you're dead. So I think just the nature of work changes. And to be honest, our work isn't laborious. We're not breaking our backs. We're sitting at our desks. We're typing away. Your brain can stay pretty active as long as you keep yourself healthy and minded. So I can't see myself retiring as a small business owner, but I can see it evolving and changing in different ways.
What would you define retirement as?
Doing what you love and just maybe working part-time, right? If I was doing what I love, I'd be a gym instructor. I'm working at a boxing gym. Now, being 40 years old and with 3 kids, I'm not going to go start again and open up a gym, right? But as a business owner, I know that I can set my business up where I can plug in and play wherever I need to. And then work changes by, say, doing 3-4 hours every other day and having... Right now, I like to have that work-life balance, and I think I do it somewhat successfully by being home for my kids.
How old are the kids?
12, 9 and 6.
Okay.
So
they still need dad around.
Yeah. And, you know, I didn't have a father around when I was a kid. So in the back of my mind, I'm like, okay, I want to be there as much as I can. And COVID actually helped me realize how much time you miss out as a father in those first few initial years, because I was able to get real close with my son during that first 6 months where my wife didn't need to put him to bed. I was putting him to bed straight away. Whereas with my daughters, it took to that first 2-year mark for them. And it was like breaking an umbilical cord, right? Because they just wanted their mum. And it's a bit of nurture, and, you know, the male comes more into that active lifestyle, the sporting moments and all that. And I'm enjoying that part of it now. I don't think I'll ever get sick of taking them to sporting things like yeah, it's a banality of every parent. But I think they're the times we live for, right? We see them grow up. We see them experience life, go through the hardships, learn about discipline, learn about teamwork. And they're the core principles that we're raised with, So you want them to have as much upbringing in a good society. And like I said, we live in the best part of the world. There's only, I don't really meet many morons out here. There's a lot of good people that live out here, and people like the parents we surround ourselves with have the same principles. So, yeah, it's a lot of fun, but yeah, it can be difficult with 3. I mean, I can't imagine how you do it with 5.
Oh, my wife's a superstar. That's it. Without our other halves, it makes it pretty.
Yeah,
it makes it pretty difficult. It's interesting when you're talking about COVID. Actually, it's funny. I look back on that time fondly of the 2 weeks to flatten the curve became 6 months. I love being around the kids for that prolonged period of time. The kids were at home. We're having, cooked lunches every day.
Yeah.
And spending time just with the kids, doing, going for a walk, going for a ride, spending all day with them. It was nice to some degree. A lot of the things we didn't enjoy about it, but I think when we started to think about what our purpose is, it is to be great examples for our kids and raise good humans.
I think a lot of people reevaluated their values and goals in life at that stage as well. And I'm grateful again that we were out here because we had more freedoms than what people in the concrete jungle in metropolitan Melbourne had.
Ring of steel.
Yeah, they were basically jailed in their houses. And so I empathise with what they had to go through mentally, because that would be so difficult, because we found it difficult and we're still able to get out of the house, take our kids down to the beach, go to the park, and again, we created some really close bonds with our neighbours, as you would, when I was getting raised in Yarraville, our Italian neighbours were like family, like mum was Calabrese, so they'd come over, take the washing off the line for us, babysit my brother and I while mum was at work because she was a single mum, right? And that is when I realised, at this age, like you said, we can only do what we do because of our wives. And that's why they always say, give me a successful man and I'll tell you the woman behind him's even better. And I'm the same. Like I don't have the mental capacity to deal with what my wife deals with. I really don't. I think I've got too much stress from work, and I try and turn my mind to home, and there's just so much going on at home with each of the children that I'm like, she's literally, like, women are literally superhuman.
Yeah.
It's crazy to think the world's a bit backwards in that regard, to not recognize that a lot earlier. I don't know where we forget that along the path either, because when we're teenagers, we know women are a lot more emotionally self-aware and smarter than boys. And somewhere along the journey, we forget that they just have a lot more capacity than what we do to take on so much more emotionally, So, but we digress. And as, like you said, as parents, we want to be good role models, and, doing what we do health-wise, but also turns back to financial planning and teaching them good lessons. Like your dad teaching her, my mum was the same. She used to take half my wage and put in an account to save for me. And I wouldn't do that if I was a teenager. Like, she got me investing in property when I was 19.
Yeah.
I would not have bought an apartment at 19. And that set me up to be able to come out and own a home in Torquay. Admittedly, I got in the market very early in 2015. But that's because I was financially inept to say, okay, I'm looking at contracts, and I'm looking at contract as a property lawyer, thinking, geez, there's already a fair bit of yield clients are making. People, vendors are making 100, 200 grand on properties in 2015. I'm like, if I don't jump in now, I'm going to miss the boat. And literally 12 months later, I was attending auctions in our development area, and the same size block was already going for 150 more. And now, like, the block I've got is 608 square metre. I bought for half the price of what the market value is now. And it's just crazy to think, how do people afford now to build in and around the Surf Coast area?
Well, it's a bank of mum and dad. It's there's a lot of that happening. You probably see that a lot in sort of in the conveyancing world, that people are having to lean on other parties to get access to funds, use other parties' security or guarantees for property purchases. I think it is, particularly in Victoria, it is unfortunately the way it's going to be. The next, this probably flows nicely into like this idea of protection of assets and the flow of assets. I mean, there is a huge transition of wealth about to occur. I mean, they're talking about it's $3.5 trillion of superannuation that's going to change hands over the course of the next 2 decades, and it's the equivalent in property Australia-wide.
Yeah.
Like there's going to be, we've got, clients on both sides of that, the clients that are the baby boomers that have the assets. You've got the sort of Gen Xers, myself, that are going to be in the midst of sort of the sandwich generation of looking after their parents, need to make sure that they can accommodate the receipt of those proceeds, and then wanting to look after your kids at the same time. So, it's going to be an interesting decade or so.
So many machinations of that as well, because, culturally it's very different for Europeans. Like the elderly will come into the home. I'm dealing with clients who are talking to me about, putting their parents in aged care facilities, what that means for a RAD, which is a refundable accommodation deposit, what that means, and they're thinking long term. They're thinking, okay, mum's 75, 80, she's got a few debilitations in terms of heart health or mental health. She might have dementia. Mum's not going to hang around for much longer. What does that mean in terms of that aged care facility taking their exit entitlement payment or the deferred management fee? That means I'm going to lose 100. So they already have this mindset of, okay, what am I going to be receiving in the end, instead of the actual welfare of your parent who's actually raised you, right? And it's scary because, like I said, I've got my mother-in-law who lives with us. She was by herself when we decided to put a granny flat in the back of our house. But I think it was one of the best decisions because our kids get to experience the multi-generational teachings. She'll be talking to them about how she was raised. She'll be raising them about how she was raised, which is how she raised her daughter. But then also she gets the benefit of being around her grandkids. So I think it keeps her young. She's continued working from home. She travels a lot. She's got her own group of mates and she's loving life. So, you want to see that for your parents, and you want to see them enjoy life into their later years. Like I talk to mum about retiring all the time. She's like, I can't. I'm like, sell the house in Spotswood. I don't want to pay the tax. Get rid of it. Go, go travel the world for 6 months. Like I really don't care. Like you've done your job. I'm fine. I'm well to do in terms of having a house and a kids and all that. That's my financial responsibility. I don't need you to keep that house for inheritance purposes. Just sell it. Pay the tax and enjoy life, right? But going back to that protection element is, you see the bad advice that happens, and clients come in with multiple investment properties and they're business owners and they've got houses in their personal names. And then lawyers will say, for asset protection, we'll transfer, for a PPR, you can do a spousal transfer, no stamp duty. But for any investment properties, you're paying stamp duty on. And that changed a while ago. Queensland, we've basically followed Queensland, but about maybe 2018-19, just before that, you could transfer investments on a non-dutiable basis. And people don't realise the liability that they're exposed to creditors if they're going bust, essentially. And a lot of people, and a lot of lawyers will give the advice, for asset protection purposes, let's transfer the property, but they don't add the extra advice. Because if you transfer the property for asset protection, meaning as a business owner, you don't want creditors to have access to that asset, a court, if it ends up at federal court under the Corporations Act, a court will look at that transfer and they'll go, well, that was done to defeat the purposes of creditors. So therefore, that's a void transaction. We're actually going to trace your asset now and we're going to get a hold of that. So I'm constantly giving clients that advice is that as a business owner, you can't just do this to defeat creditors. But if you want to do it to put it in your will and gift it to someone specifically, and then we're doing it for estate planning purposes and you're crafting your will at the same time. And then all of a sudden you've got the asset protection for the correct purpose. And then we're talking about testamentary trust and we're talking about the tax advantages and asset protection that a testamentary trust can provide you. Kids will always come to me, the adult children will come to me, their parents are deceased. They're like, I want to put that property in a trust. I'm like, well, your will has to go directly to you. You want to put that property in a trust, you're paying stamp duty at market rate, and they can't afford it. So they have to take it on that personal liability. Now, unfortunately, most assets of a deceased estate get sold. So the property will get sold off and then the money's split evenly between the kids. But what happens if you want to take advantage of that asset, keep it, let it materialize, rent it out, and then that profit gets distributed across multiple beneficiaries, and people won't realize that you've got both secondary and primary and secondary beneficiaries, and your second beneficiaries are where the real advantage comes in, because you're giving a gift at your discretion to beneficiaries that maybe don't earn an income. So therefore, you're essentially getting that gift back tax-free.
So let's, for the listeners, explain in simple terms what a testamentary trust is.
So it's essentially a will that incorporates a trust in different schedules for different purposes. So normally your first schedule is a testamentary trust that's created for the benefit of your spouse. So that's your first trust creation. And then you can create separate trusts for each of your kids, and you can have specific assets go into different trusts under those schedules. So when you're talking about a corporate trustee of a discretionary family trust, that's a lot. Like that's during your lifetime, that's a company entity. So that's, registered with ASIC. It's currently trading, or it could be a property investment trust, but it's essentially a family trust sits behind that. That doesn't go in after you're deceased. So once you die, that you have to have succession planning for that. So you have to have deed of appointment and retirement, or you have to have some sort of special resolution if it's a trading entity as to what's going to happen. Because essentially, if you're in business with someone, you don't want to go into business with someone else's wife. You want to make sure you have that succession planning in place, and that's where company power of attorneys come into play as well. A testamentary trust are trusts that are created after your death. And people often ask me, well, what's the advantages of that? There's three main advantages, and I've already mentioned two. You're tax advantageous, asset protection, but then also wastage. If your kids are inheriting 300 grand and they're 21, what do you think they're going to do? A long time ago, 21, 22-year-olds were professionals. They had kids, which was fine. But now the age for when kids are getting their estate is pushing out to 25, 28, 32, right? When they're more settled and they've got some HECS debts they want to pay off, or they've got a mortgage that they want to pay off. But with a testamentary trust, you're essentially going to your plan and your accountant, and you're getting the best tax advice on how to take advantage of that asset over the course of the perpetuity period, which is something like 89 years. I'd have to look it up. Don't quote me on it. But, you've essentially multi-generational legacy, giving financial security to your kids, and then to their kids. So, when you're talking about the old school family heirs, and that's why they brought in the perpetuity period, because they realized people were tying up assets through the entire generation of kids, and it was the old, lords and leaving it to their heirs, and that was normally the male in the family. So it's sort of, it's sort of mimics that, old adage from English times, but it really is setting up your children for their lifetime. Because say your child gets the benefit of a trust, they're the trustee, and then all of a sudden they separate from their wife. And this is always the concern from the will maker, is my son's going through a rough marriage.
What if,
what do I do? And the trust is set up in a way, so it is still discretionary. If you know you're going through a separation, then you don't have to take any trust distributions. You don't pay yourself from the trust. You're essentially sending it out elsewhere. Now, unfortunately, the family court, being a creature of Commonwealth jurisdiction, and having learnt in that space while I was studying and working in various family law practices and at legal aid for a fair bit, you see the mess that it creates when people are going after inheritances, especially even in amicable breakups. People are like, oh, well, he's going to get inheritance, even before they've got it, Inheritance shouldn't really play a part when you're divorcing. But if you've got a testamentary trust set up, that problem goes away, because you're a mere beneficiary. So again, you don't have a legal entitlement to any of those assets. Now, the family court, there can be submissions and arguments made that you've been receiving trust distributions over 20 years for your marriage. The marriage is broken down. We're going to put that in the asset pool. Now, fair enough. I think people who are in 20-year marriages have to pull their heads in and realize that a marriage is exactly like a business partnership, and they compare it to a business partnership, and that's why they call marriages constructive trusts. When you're lodging a caveat as an ex-wife or a de facto, you're basing it on a constructive or resulting trust. That's the equitable charge that you're allowed to lodge on a property. So when you're breaking up that business partnership marriage after 20 years, of course there's going to be an entitlement to your super, or where there's been a homemaker parent and someone's been able to excel in their employment and earn a significant income, and there's a disparity. the court has to create that balancing act. So there's a bit of a 50 split, 45-55 split, whatever it may be. And then you've got different machinations. You've got kids who have future needs, autism, all that sort of stuff. And that's for the courts to decide. But the Family Law Act encompasses now everything. Your super, your corps, your forensic accounting, your testamentary trust. They can grab at it. So you need to go to a sufficiently experienced solicitor who deals with quarantining assets in a trust so they can't get grabbed at.
What are some of the common mistakes with testamentary trust that, again, I'm not a solicitor. This is your wheelhouse. But in terms of if I want to set up a testamentary trust and the trust has one trustee, that trustee is also the sole beneficiary.
Yeah, that's a no.
Okay,
definitely.
Yeah, so
you want to have at least two appointors of a trust,
right?
You want to have two.
So explain what's the appointer?
So you want to have two trustees of a trust. So essentially like your executors. People will say, who's my executor? But when you're an executor, you've also got the hat on as trustee. After you're appointed as under a grant of probate as the executor, your role then turns into a trustee. Now, trustees have fiduciary duties. They're the duties we have to our clients. As professionals, fiduciary duties are our best interest duties. We must comply with acting in our clients' best interests. And if we don't do that, we get sued. Same as the trustees. Under the Trustees Act, you've got those same fiduciary duties. So under a testamentary trust, your appointors are also your trustees. So that way you can do deed of retirement and appointment of so if it doesn't suit someone to sit in that position of trustee, you're retiring them and appointing a new trustee. You can't really have a sole trustee and a sole beneficiary because that means you don't have a mere entitlement. You've actually got a legal entitlement.
Yeah, you own the asset.
You're the only one that can make the decision. So I see current trusts in those situations now. So we immediately amend those trusts to appoint a second trustee and a second director of the company. So there's no sole discretionary decision-making power on the sole director or sole trustee. Similar situation in testamentary trusts. I think testamentary trusts can be overborne and overcomplicated by the layperson and by solicitors. They'll blurt out all their legal knowledge and what can and can't happen. And the good thing about seeing a solicitor is that we've got that foresight to say, okay, what's your particular family circumstances? Who's the blended family? Where are the pain points? And then we can craft that testamentary trust so that we may leave a child off as a trustee, but they're a beneficiary. And even then, some people may even leave them off as a beneficiary, knowing that they'll still be considered a secondary beneficiary. Because we say colloquially in the profession, secondary beneficiaries under a trustee are the world at large. So it's funny because when we're filling out duties forms for clients who are buying properties under their SMSF or another investment corporate entity, it'll say, is this company entity a trust? Yes, it's a trust. Okay, how many beneficiaries? Oh, how would you like us to answer that question? So we basically just name
the world.
Yeah, we basically just name the primary beneficiaries in that answer.
Yeah.
Because the SRO wants their land tax surcharge on the property, so they want to know which trusts, and you can't have trusts registered on titles in Victoria. You can only have the company name. So you have to do an extra notification, which can be a problem because some conveyancers just don't know about this and don't do it. And then SRO writes them a penalty letter saying, we believe this is owned by a trust. We're going to backdate all our land tax surcharge and charge you penalty interest. So back to testamentary trust. So it's just, I think, when people think about them, they may be scary, they may be too scary because they're quite voluminous and wills and estates is one of those areas that like to hark back to the old verbiage that lawyers would use. So when you're reading a will, you're like, what the hell? I need to interpret this. I need to plug it into ChatGPT and see what it means. But the reason why they're created is to give you that tax advantage mostly. But I think from what I'm seeing now as people's most concern is asset protection. Divorces and 2 in 3 at the moment, so people don't want, and I think the main, my wife and I both work in law, so we've discussed what we're going to do with assets if we ever happens. I mean, we don't talk about divorce a lot. We just had the initial conversation, and then we know all right, if this ever happens, this is what we're going to do with the property because it's going to be left to the kids. People are ultimately concerned about repartnering. And where there's a new partner and you live with them, that new partner is going to cut. And, money makes people funny. You see it all the time where they've got the best of intentions. No, I'm not going to claim. Next minute, well, we had a relationship for 6 years. I think I should be recognised for my contribution to the... I don't blame them. We're living in tough times. The cost of living is seriously dangerous. People are living paycheck to paycheck. People think lawyers make a lot of money. We don't. You can go to every corner, you'll find 5 lawyers, just like in financial planners and accountants, right? So not every lawyer is making absolute bank on a client. And for me, it's not about the billable hour. I really don't care about leaving money on the table. I'll just rather put that client in the best position possible moving forward. And I'll be very transparent with my fees in terms of what we charge, because we do fixed fee legal services. So it's more value priced on, okay, this is an obligation-free consult. You're interviewing me to see if I'm the right person. I'm seeing if you're the right client for me, because if you're going to lie to me, then
we're out.
I'm dropping, And I've dropped plenty of clients who I feel don't pass the sniff test. And like you said, it's those soft skills that you learn. Being at Legal Aid, for 8 years, I walked out of there and started interviewing for jobs in private practice. And a lot of principals were like, you got more experience than some of my lawyers. I did a lot of volunteering in different roles and, appearing in the infringements court and doing advocacy work, working for the Public Interest Law Clearinghouse, which is now Justice Connect, doing Environmental Defenders Office work, which is now Environmental Justice Australia. So it grounded me in what I know, what I like to do, and what I find value in delivering for clients. And it's just heartbreaking when you have a client who calls you and says, my wife was told she had 2 years to live. 2 weeks later, she's gone. I think I feel like emotionally I need to get a lot more stricter with clients who have kids as well. Because it's like, oh, where are your kids going? Are you appointing testamentary guardians? Like, I've had clients call me and say, oh, my brother's passed away and the Department of Housing's called me and they're estranged from their brother. And he's got 3 kids. So those kids then are institutionalised in the foster care system. So it's like, well, what's going to happen to the next generation of children who are then raised in that, with DHHS? Not everyone knows it's not a nice demographic to be in. Like, you look at Parkville Youth Justice Centre and the amount of recidivism that's happening in youth gangs and whoever they may be. Unfortunately, kids find that as a badge of honour now. And I worked in the child protection jurisdiction for a bit at Legal Aid, clerking at the courts. I think people aren't aware of the underlay of society that think that that's the norm, and then the middle class that would look at that and go, that is completely alien to how anyone should be raised. But kids are being brought up in squalor and, they just get lost to the system. And we're here as middle class parents trying to, and that's why sometimes it's institutionalized, that wealth creation. But ultimately we're worried about our legacies moving forward. It's scary to think how families aren't dealing with their current situation, and then it's really left up. Everything's left up in the air, and that's where you hear that saying, "Oh, your money goes to the government," which isn't entirely correct. I get really upset when people appoint the state trustees as an executor. Like, state trustees are charging 3% commission or more on your estate, and there's one house and one bank account. I'm not charging 3% executive's commission on anything as a lawyer, even when I am appointed as the executor. I'm literally doing the legal work, charging my professional fee, and that's it. Like, if I'm appointed an executor, that means I really know the client well, and we're personally acquainted. We know each other's lives intimately, and I'm happy to sit in that role knowing that there's people I can rely on in that family to execute some of the work I need to. But some lawyers we'll get questioned at court if we get charged 3% commission. We should only be charging about 1.5, if that. And some lawyers get appointed executor and their eyes light up. Oh, I charge 3% on $1 million property. That's a good payday for a lawyer. Or their costs disclosure will be based on a percentage of what the estate's worth or a percentage of what the contract's worth, so they can start making more money. Whereas we literally just have that consult, see what the type of work needs to be done. Say, even if it's to purchase a business, for example, what is it? You're buying a client book or you're buying a fish and chip shop. How much work's involved? Do we need to do a transfer of lease, or do we need to discharge any PPSR charges? And then we can actually provide a more informed quote on what they expect to charge. some of the stuff clients get charged just on shareholder agreements surprised me. And then I find out where the lawyer's from, and I'm like, oh, damn, you're paying for the brand, you're not paying for the work. And some of it's a lot simpler. But with testamentary trusts, they're very underutilized by current day professionals who are our age. And they think, okay, well, I don't need to worry about that until I start retiring, which is fine. But then anything can happen between now and when you start retiring. And same thing with enduring power of attorneys. It's like you may not need now, but when you do need it, it's always in emergency situations. And who's running around to, like, I see clients go to lawyers' offices when I'm in there, just doing settlement work and meeting with other lawyers. And then come into my office, I need a copy of my power of attorney certified. I need to come in today, because they need it immediately. And what we do is we partner with a company called Wishkeeper that gives access to gives those documents to those clients immediately from an online portal that's secure. So, say, for example, client comes to me, wills, powers of attorney, binding nominations. They all go on an online portal. They get access to those. They can give access to their attorneys through that portal. So if their attorneys never ever need to go access a certified copy immediately, they just go on the portal, download it. They can take it to the doctor, take it to the bank, and use it immediately instead of having to rush around, and get charged $6 per page for certification. It's like it's already there. It's there for you, And this is it's a holistic service because we know what can happen in the person's lifetime. So we'll give them a copy of the will to take home with them and put them in the safe, but we'll also certify their power of attorneys physically for them to keep in the safe, and then we're giving them the online portal option as well. So it's just really covering all bases. But yeah, testamentary trust is one where I always harp on about the three main advantages of, and they only really come to me when they experience those three difficulties in life in terms of asset protection, marriage breakdown. But the most tax advantageous one is the one you want to bank on, because if you've got multiple assets, you've got investment properties, which most people do have one or two investment properties. You've got corporate trustees. You want to make sure everything you've built during your lifetime is left to your kids. So
yeah, and then you want to make sure that if they happen to make some bad decisions or some bad relationship decisions themselves in the future, that legacy is still protected. And
they're going and talking to the right people, right? Like they're going to your financial planner, they're going to your lawyer who they've the will makers trusted to do one of the most important documents during their lifetime. So they, the testamentary trust will say, before decisions are made, you need to go and consult with the financial planner. Now, it's to their discretion whether they go speak with a planner or an accountant and get that financial advice before making major decisions, which you should do anyway when you're distributing through a trust. Because remember, it harks back to those best interest duties, those fiduciary duties. You still have duties to the beneficiaries of that trust. Now you've got those primary ones that they're the main duties to, but you don't want to put them in a worse tax position or a worse position if they're going through a divorce in court. You want to go and talk to someone who's actually going to guide you through and have that foresight and say, okay, well, this is the best way we can distribute these trust assets that are going to help you out in the future. So yeah, I think it's extremely underutilized. I think sometimes lawyers will overcomplicate them, but yeah, I try and just take it back to basics and say, these are the three main advantages, and you tell me what you want to do. I've had clients who will change their instructions halfway through that will making process, and they go, well, no, we need a testamentary trust. We want to make sure that that asset's protected for my kids' futures as well. So
mate, that's estate planning. That's powers of attorney. We haven't touched a lot on the conveyancing side of the work that you do. So you said primarily your estate planning, conveyancing, they're kind of the
hand in hand.
They hand in hand, and they go along with two of the bigger milestones in people's lives. Talk to me a little about the conveyancing side of the business.
Yeah, I mean, normally, and the reason why they go hand in hand is because when you're doing your wills, it's normally at those major junctures in your life where you're buying your main asset or you're buying investment property. And conveyancing, and there's a lot of conveyancing factories out there that will just chew you up and spit you out. I had my first experience when I was 19 buying an investment property, and I got a call from the conveyancer, we need $6,000 in our trust account. I'm like, this is the first I've heard of it. What are you talking about? It's $6,000. No one told me this. And it can be quite a stressful time for consumers, especially now in the online world. all conveyancing's online. It's been mandated for some time now in Victoria. So it's very difficult to be able to charge a high price point, but then show your work, because clients will not see the paperwork. You literally see the client maybe for the initial paperwork, because that can be done online now as well, like in terms of your verification of identity and such. And then everything's through the portal. And what I like to do with conveyancing is bring in the professionals they're working with, the mortgage broker, the real estate agent, and leverage the relationship to make sure it's a smooth transaction to the end. And, with conveyancing, it's a fixed fee service. I've done my market research around here. Good conveyancers charge as much as what I charge. The advantage of using a solicitor is mainly your public liability insurance. I've heard analogies like, do you want the nurse doing the heart surgery?
Yeah.
Which is a bit harsh. Like, there's conveyancers around here that are well known, that are very well regarded, that do a very good job. But there's good and bad actors in every play. There's good and bad actors in our profession. There's good and bad actors in the conveyancing profession. I mean, the difficulty we're finding now is referral fees. There's a conveyancing company paying real estate agents $400 in referral fees, but the client is paying that in the end. And what they're doing is they're carving that out of their cost disclosure, because in Victoria, as long as you give informed consent to the client. Now, what's informed consent? No one's read. I know half of my clients don't read my letters. They're not reading my cost disclosure. And I'm very transparent. If someone's asking me for a quote, and even when I see they're fishing for it, like they email me, oh, what's your cost? I'm very transparent. This is what we do. Holistic end-to-end conveyancing. You get me. You don't get my receptionist. You can call me whenever you like if you need any clarifications. There are no stupid questions in conveyancing, because no one really knows what goes on behind the scenes and the machinations of conveyancing. And sometimes it's people's only real interaction with the solicitor. And I've had family members who don't even realise I do conveyancing, because they think, oh no, he's just a property lawyer, he doesn't do conveyancing. And that's why the business name is HG Legal and Conveyancing, so people realise that that's part of the service delivery. But it's really that end-to-end service where it's like, you can pick up the phone and call me, and if you need me to push a button, it'll be done. Like, I'll return all my calls within a business day to make sure that I'm not missing. And same as emails, if I see an urgent email, it's being actioned immediately. And so I'm talking to the bank. I had an interesting one recently where the client emailed through and said, I don't want to deal with Paul Snow anymore. I thought, oh, well, what's going on here? So I touched base with my paralegal who assists me in the conveyancing process, and he stepped out at chronology. I ended up getting back on the phone to the client, finding out it was an actual broker who was throwing me under the bus. And the broker, he was literally in writing pointing the finger at me, saying, oh, we've received a PEXA error. This is your solicitor needs to fix this. I've gone back through the documents, and I'm like, we have done nothing wrong here. We've been timely in our communications. We've prepared the documents for the bank as required. Like, maybe the most we had gone without responding was a 3 business day turnaround to the bank and the broker. I'm like, geez, the broker's really gone hard here. And I had a chat to the client. I said, listen, I can assure you I've reviewed the file. We've gone through chronology. There's nothing gone wrong on our end. I said, if I've made a mistake, I'll put my hand up and take accountability for it, because as a professional, I feel you have to. And if you take accountability for it, people have more respect for you. I said, I don't know what's gone wrong here, but I have a feeling that your broker was basically pointing the finger at me. And then it was subsequent to that that the client forwarded an email to our receptionist that had the line from the broker. Your lawyer needs to fix this. We've found out since that the broker hasn't issued the correct instructions to ANZ. The loan documentation has gone out in only one name, not joint names, when we prepared a nomination at the very start. And I got an apology from the broker. I didn't get an apology from the client. I got an apology from the broker, though, which is enough for me, because I'm like, I stood behind our accountability and what we're able to perform. Now, invariably, there are mistakes. We're not robots. We are human. It does happen. My paralegal's not perfect. He's 3 years into his career. There's going to be typos. But if you put your hand up and take accountability for it, when it's not detrimental to the client in terms of monetary, like if I make a loss on a client because of my mistake, I'm negligent. I expect to get sued. So we're always crossing our T's and dotting our I's because we're worried about our own liability, which is a bit of paranoia, because when we're giving advice, it's that worst case scenario advice. Listen, I'm giving you this worst case because if this ends up happening, you can't tell me I didn't advise you, so you can't sue me. So it's a bit of cover your ass exercise. We call it a CYA letter. But we work with worst case scenarios because we want to find out how risk averse the client is. if this is what you want to achieve, yeah, we can try it. We'll go that way. But if it goes bad and goes south, this is the worst case scenario, this situation. We don't find that that's more in litigation in terms of the risk spectrum and negotiating outcomes. Like I'm trying to really rein clients in to mediate an outcome. I'm like, do you want to be stuck in court, spend $100,000 for the next 2 years? I'll get paid. I'll be happy. But is that what you want to go through? So I'm reality testing with them all the time on disputes. With conveyancing, you don't really have much disputes unless it goes south really bad. But we always have these timeline turnarounds to ensure that clients are informed well before settlement about any shortfall funds that need to come into trust. We're liaising with the broker on what their figures and what their sums are, talking to them about, okay, what stamp duty discounting concessions and possibilities do we have? A lot of conveyancers don't go through that level of detail with the stamp duty concessions because they're not lawyers. They don't want to give the advice because then they don't want to be liable. They'll rely on the broker. But I know some of the brokers out here will rely on the solicitor for that advice. They don't go into that level of detail. Like there's a stamp duty concession on commercial properties out here that gives you 50% discount on an industrial, commercial and retail factory. Just because we're in a regional postcode, you purchase a factory, you're going to use it for those purposes, you get a 50% discount on stamp duty. Now, you can either do that or enter into the new commercial industrial property tax regime for the next 10 years. Now, which one do you want to do? You want to pay a tax 1% on a loan for stamp duty, or you want to pay 50% off now? And so we're always going to that extra length. Like if I look at a contract, we always do, obligation-free consults are just part of the industry because that's how you onboard a client. But I might look at 3 or 4 contracts before they end up conveyancing, doing like signing a successful. Other lawyers who will do the obligation-free consult and the client's not successful will charge on that consult $350, $400. I feel like part of my tagline and part of the ethos that we work with is, accountability, transparency, and empathy. So I've created the tagline, which is a bit cheesy, is providing peace of mind before signing on the dotted line. So whatever I have to do for the client to get them to that stage where that means actually putting in the structure format, this is how your offer should be put, and these are the special conditions I recommend getting certain. Now, they don't go into every contract, but where the client wants it, they'll get it, that extra level of detail. And then if I'm looking at a contract and I see a building permit, I'm going to the VBA disciplinary register. I'm looking at their license. I'm going through VCAT's jurisdiction and just searching Aussies and seeing if there's any litigation against that builder. If I see, for example, a Section 137B report on a defect, like in terms of a defects report for a deck or a veranda, I'm just giving them the reality that, hey, 80% of homes in Geelong have illegal building works. That's how it is. So either you can take that on, or worst case scenario is council issues a building notice to rip up the deck. Now, how much is it to rip up a deck? I don't know, but that's what you have to consider when you're conveyancing. Other things like planning overlays and restrictions. I get clients all the time. I want to find out what use they want to make of that property. If you're subdividing, or if you want to use it as an Airbnb, or if you want to use it as a rooming house. Like if you want to use it as a rooming house on Airbnb, you're not buying an strata title with an owners corporation because it's too hard to get consent. You need a special resolution, 75% of lot owners. Now go to Armstrong Creek and ask for consent from Armstrong Creek. You're not going to get it because of the amount of titles that are based in that owners corporation. But also in terms of development overlays, clients have wanted to build in a regional area and don't realize they've got to spend $150,000 on a fire bunker because of the bushfire management overlays that are on there. So we're going through that extra lens to find out, okay, what's your particular use? If you're wanting to subdivide, let's have a look. Is it just general residential? And it's okay. This is my advice. But call the planning department at council. They have a town planner internally. Here's a town planner you can call and get some advice off and have a chat to, and they can give you a good idea about what type of costs. Because again, when you're talking about a subdivision, it's not just legal costs. There's land titles office registration fees, there's town planner fees, there's council fees for lodging. You might have to lodge a Section 173 agreement, which binds the planning permit conditions to the title as a restriction. So, we see them all the time in the development areas with Section 173 agreements because council wants the developer to obviously do the civil engineering works in a proper manner, do all the water road connections, build the crossovers, have power core connectivity and all that stuff. So there's so many, developer contributions to council, and then it could also come to the client where they've got to pay for an infrastructure contribution once they get a building permit. I had to do that in Torquay. We paid $900 to council once we got the building permit because that was just part of the Section 173. So we really are crossing our T's and dotting our I's. And sometimes it can be a painful exercise. You have some clients who are not au fait with Australia's property law jurisdiction, and the question's, okay, what does this mean? How does this affect me? And, you want to make sure you're stepping the client through that and holding their hand. And then on the other end of the spectrum, you've got builder clients who do this every day of the week.
Yeah.
Who are like,
just get it done.
Just tell me if it's okay. And I hate the whole, does it have any red flags? So I'll still go through my advice piece, and then at the end I'll be like, I'm comfortable to say that you're happy to proceed, no red flags. And I know clients will literally just skip to the end and go, yeah, no worries. Or, with my advice pieces on conveyancing, they're very thorough in terms of walking them through the special conditions and the vendor statement. So I will do the consult, and I'll say, this will all be put in writing for you, so you've got a record of it, but I'm giving it to you verbally. I know sometimes, I'll get clients asking me, what's the stamp duty fees and registrate? Have a look at my letter. It's at the final page of my letter before I discuss my costs, So again, very transparent and accountable for our own work in the conveyancing space, because the number one of the top two complaints for our insurer that sees for professional negligence is conveyancing and family law. So there are so many, some firms will advertise that there's 170 hotspots you need to be aware of when you're conveyancing, but that's for us to take on. You just need to know what you need to know, and my role is to make sure I protect your best interests.
How many clients have come to you with buying a property and don't have their estate plan in order?
The majority of them.
Yeah.
And we're telling them, as soon as they finish their conveyancing matters, get your wills done. And some will, I think I'd say maybe 10% will follow through on that. And what I want to do is
have a package service.
Yeah. And give them more communication in that regard and the advice about the utility of it. Because I think what happens is they go through this major process, and moving is a big thing. It's a major thing to move your house and belongings, and you do a bit of a cull, you do a bit of a cleanse, and then you settle in, you take a deep breath, you're like, oh, I'm home. But it's like, okay, what's going to happen to that home after you die? And again, how do you own that home? Is it joint proprietors or is it tenants in common? Is it 50-50 tenants in common, or is it 70-30 tenants in common, which is unequal or equal shares? And you can craft them that way for estate planning purposes. But it's hard, because what will happen is your final letter will fall into the ether, and we're trying to give incentives for them to come back and do their wills. But again, I have clients who are onboarded on wills, and draft wills will sit in the ether for 6 months. And I think the major touch point and sticky points I need to create, which will be created, is providing more value. Like, have automated emails going out saying, hey, this is what an informal will is. Okay, if you can't come in and to do your informal will, hey, your will still hasn't been done. It's been 8 weeks. What's going to happen to your beneficiaries? Just create more communication about the value out of getting it done, because conveyancing is a need, right? They have to come to you to do it. Wills and estates isn't a need until it is a need.
Yeah. Yeah, I think about something you said before about being more, I don't know what you actually said, being a little harder, a little firmer on conversations you have with friends, family, colleagues, clients. Sometimes people are a bit bemused when we're talking to them about estate plan. They've come in with, to talk about buying a property or their superannuation. We've been obsessed as a business about making sure that we've got eyes over what clients' estate plans are, and we'd like to have a look at the people's wills, their powers of attorney. We want to be able to point it out early on in the piece. And I think anyone out there listening to this, if you take any of those significant milestones in your life, whether it be the addition of kids, the purchase of a property, the sale or the purchase of a business, it's a perfect opportunity to do a financial an estate planning health check and get your shit in order. Yeah. Because again, it's not a problem until it is a genuine problem. And you, Paul, and myself over our time have seen plenty of things go pear-shaped, and it's not the side of the fence that you actually want to be on.
I empathise. I really get close with my clients, and I can deal with the crying and the emotional empathy, but it gets to me too. And I'm sure you feel that in your profession as well. and that's why I like partnering with Wishkeeper, because it's giving access to professionals as well. Do you want your financial planner to have a look at these? Because bang, they get a link, they get access to it. They can even, like, I know a client who is video recording and chucking it on that platform, so that it's sort of an exercise where that movie P.S. I Love You,
Yes.
where they're leaving video messages for their kids so they can continue teaching their kids, which is beautiful, because the first thing you lose when you lose a loved one is not just obviously the loved one, but is you end up losing the sound of their voice. And they're the things that you want to, like, I'm quite lucky I've got my nonna on my wedding video. I'm the only grandson to have my nonna there because she passed shortly thereafter. But I watched that speech and she's speaking in Italian, and it hits my heart every time. And when I go do like passata tomato sauce day with her sisters and my aunties, I hear my nonna, because they're talking in that dialect. They're speaking exactly how she speaks, and I'm taken back to my childhood. So that platform, Wishkeeper, you can have your letter of wishes, but you can also include your motor vehicle insurance, your share portfolio statements. The hardest thing for an executive to collect at that time is bank account statement. I know a wife who doesn't even have access to her husband's bank account.
Yeah, it's a great point. I think that from a financial health check, like a consolidation, doing a stock take, like how often do you actually do a stock take and actually collate and reconcile exactly what you've got and have it in the one spot, whether it be multiple superannuation policies, odd insurance policies, funeral bonds.
Yeah.
Let's make sure they're consolidated in the one spot. And there is, like you said, there's technology now that allows you to do that, and it doesn't need to be onerous.
And, financial planners and lawyers go hand in hand. Like when clients are coming to me for their wills, I'm like, have you discussed this with your financial planner? We'll ask them, who's your accountant, who's your financial planner, and who's your insurance broker? We want to know so that we can talk to them. It's like, okay, now that you've come to me, and like in terms of financial health check, I agree. Like wills and estates planning is a financial health check. It's not just a legal health check. It's got to do with all your financial legacy. So go and have a chat to your financial planner, as well as talk to me. If we're doing this exercise, let's make sure we're doing our due diligence now, because you can set and forget it, as long as obviously nothing major happens in the interim. But you want to make sure you're thorough in your instructions to both your planner and your lawyer about that.
Yeah, I think we have a common ethos there, in that we want to make sure that we work with and collaborate with the professionals that sit around our clients, because I think that's where we get the best result. And as we were talking earlier about sort of AI and sort of automation, if you're in financial planning or if you're in estate planning and you're transactional and all you exist for is to facilitate that transaction, whether it be investing money into a super or taking money to put investments in, you're not considering everything else that sits around it. Back to sort of best interest duties and our obligations to clients.
Yeah.
So if you're out there and you're speaking to a client, a lawyer, a conveyancer, and they're not asking you these questions, they're not actually exploring beyond the transaction, you might be better to go and seek some direction elsewhere.
I think so. And normally a lawyer will have a good relationship with a financial planner. And, that going back to the referral fees, it can seem that there's a financial incentive. But for me, again, it goes back to that comprehensive best interest duties. And that's why I don't charge by the $6 billable increment, right? Like I don't have a billable hour because I just don't think that's in the client's best interest to bill on that method in today's economy. It just doesn't work, right? And clients, that's why they brought in this whole cost disclosure in the legal profession uniform law, because the number one complaint was legal fees, because lawyers were just charging willy-nilly on, you think every phone call you pick up, they start the timer. That's the colloquial joke. And I have a bit of a laugh with that. Like I'll say to clients who I'm pretty friendly with, hold on, just let me start the timer just to give them a bit of stick. And we have a bit of a laugh about it because they know I don't invoice or bill on that method. But if you're not collaborating with like-minded professionals who work similarly to you, you've really got to question whether that professional's doing the service that you're paying them to do. And there's no more truism than you pay for what you get for. And if you don't essentially pay market rate or what's a standard fee and you're looking to save money, that's fine. You can do that, but just don't expect that comprehensive end-to-end service, because you're paying a conveyancing factory or a transactional service. You want someone who's actually going to dive deep into your finances and go, here's a hotspot you really need to take care of. Let's go and speak to a financial planner or an accountant. I find heaps of accountants who essentially are just numbers people, and they won't, they'll go, oh, let's handball this, and the lawyer can deal with it. It's like, okay, I need the whole map. What's the corporate trustee? Who are the beneficiaries? What's going on with the trading entity? What's going on with their portfolio and property investments? Where's it being held? We can do our due diligence investigations, but if we're not communicating, then how are we actually servicing the client to the best of our ability? So I think, like you said, going back to building relationships, when clients can see that you're taking that extra length to find out exactly the pain points in their lives, especially with blended families. And, you've got not just blended families for young professionals, you've got elderly people who are divorcing at 60 and 70 and then repartnering. You question it and you're like, okay, we really need to deal with this urgently. So, yeah.
Well, Paul, that might be a nice place to wrap up. And maybe if someone's listening to this and they want to get a hold of you, either from an estate planning point of view, a conveyancing point of view, what other services are you offering at HG?
Yeah, I mean, there's a lot of debtor recovery in terms of letters of demand. I mean, that's a hot topic because there's a lot of people who owe a lot of money. I've got a lot of debtors that owe me money, and we do our own debtor recovery stuff. We do a little bit of intellectual property law. I will pick and choose my family law clients because I only do amicable family law splits, because I just feel that anyone who's acrimonious and wants to go through court for the next 2 to 3 years isn't the type of client I want to take on, even though it'll make me a lot of money. I'm just not interested in sacrificing my integrity for the dollar. But if people want to find me, I'm all over social media. HG Legal and Conveyancing has its own Facebook page. I'm at Paul Snow Lawyer on Instagram. But then, all my contact information's online where people can just get a hold of me. I get a lot of DM messages on Facebook because I get recommended on Facebook a fair bit from my colleagues and clients who know that I deliver results. But yeah, you can say I'm a jack of all trades but a master of none. But then I won't take on something that I don't feel I can deliver a result on. And that's where, my relationships with lawyers and colleagues in the profession, I've got really good relationships with top-end lawyers in town, both in Melbourne and Geelong, that I can turn to and go, well, this client needs to be serviced by that particular lawyer. And for me, it's a bit of horses for courses, right? Like if I don't think I can get the result for the client, or it's not my area of expertise, like for example, medical negligence claims or personal injury claims, where you're essentially going out to sue someone, I won't take on that client. I'll pass them on. But mostly conveyancing, wills and estates, a little bit into intellectual property law, a little bit of family law. Just keeps it interesting. It's
good, mate. Well, I think if people are listening to this, they've got a pretty good insight into who you are and what you're all about, and the types of services and support you offer to your clients. So it's nice to get to know you.
Yeah.
I know this is the first time we've actually met, so it's good. It's good to be on the other sort of the table, listening and taking it all in. And as I said, from a business point of view, I kind of resonate with a lot of the sort of the way you deal with your clients through a relationship lens. I think it is, for anyone out there, young lawyers, young financial advisors, have a listen to Paul, have a listen to our previous podcast. Relationships are going to be paramount. Get out of your bedroom, get in front of people, work out how to return a phone call,
100%.
Get off the text. But I'd like to have you back, Paul, on maybe a round 2. We only scratched the surface on family law. I think we could probably deep dive in a heap of client scenarios there. But thanks again for the chat. And anyone listening to this, go and check out Paul on social media, look him up, and we'll speak to you soon.
Thanks, mate. Appreciate the opportunity.
We hope you enjoyed today's episode. If you're keen to understand more about how financial advice could benefit you, follow us on Instagram, Facebook, and Twitter at Burke Britton FP, or Google Burke Britton Financial Partners. Check out our client reviews, testimonials, and make a time to meet one of our certified financial planners by clicking Book Now on our website. Thanks for listening.
Any information contained in this podcast is of a general nature only. No account was taken as to the objectives, financial situation, or needs of any particular person. Therefore, before making any decision, listeners should consider the appropriateness of any information with regard to their particular objective, financial situation, needs, and seek independent advice from a licensed professional specific to their circumstances.
All right, hit it.
That translates to don't be a moron and act on what some random person says on a podcast. Take personal responsibility, do your homework, ask questions, and speak to an actual human that knows what they're talking about before you do anything. PB Financial Solutions Proprietary Limited, trading as Burke, Britton Financial Partners, are authorised representatives of AMP Financial Planning Limited, AFS, licence number 232706.